Hmm. I'm getting an error for LinkedIn today. An error occurred on LinkedIn. This is usually temporary. Wait a moment, then try again. So this is from StreamYard site, Prashanti, just letting you know. We are live on other platforms. We are currently facing issues with streaming for Facebook as well as LinkedIn today. But for all those who have joined us, we will be starting today's webinar momentarily.
Are you on YouTube?
Yes, YouTube is live. I am seeing connectivity issues with Facebook as well as LinkedIn Live from our streaming platform.
So I guess we'll wait for a few minutes.
Yes. Yeah, unfortunately, I tried again and it still says an error occurred on LinkedIn. This is usually temporary. Wait a moment, then try again. Prashanti, for our live audience on the webinar as well as on YouTube, shall we get started? And in the meantime, I'll keep trying to go live on LinkedIn as soon as I can.
Sure.
All right. Well, thank you everyone for joining us today. I'm joined alongside Prashanti Reddy. Many of you would already be aware of who Prashanti is. A quick introduction: Prashanti is an award winning immigration attorney specializing in immigration law with over 25 years of experience. Prashanti has many achievements and recognitions under her belt in her 25 plus years of career. She's recently listed by Forbes as one of New York City's best immigration lawyers in 2024, amongst a whole list of recognitions from industry bodies and outside. For today's session, we will start with immigration updates. And before that, I would like to let you know that we will be accepting questions by the end of today's presentation. So you can use your streaming platform, or if you are streaming through any of our channels, social channels such as YouTube, Facebook, and LinkedIn, you can type in your question directly from there as well. We will be picking it up by the end of Prashanti's presentation. On that note, Prashanti, over to you.
Have you been able to get on LinkedIn?
No, it still says unable to. I will keep trying though.
Okay. Because we do get a lot of people on
Yeah,
LinkedIn.
both LinkedIn and Facebook today, it seems there is some issue there.
Yeah. I was just wondering whether we should wait for a few minutes, like maybe 1 or 2 minutes.
Yeah, we can give it a try. It's just that I have been, yeah, I'm trying it again. You know, yeah, unfortunately, Prashanti, the issue persists here. We will have to reach out to support, uh, but so far, yeah, it persists on both the platforms.
Okay, so shall we start or wait for a few minutes?
I think, Prashanti, it's safe to start for now. I will keep trying in between.
Okay. Hello, everyone, whoever has joined us live. And for those who were not able to join us because of the issues that we have with LinkedIn, we will send you a recording and hopefully, if you have any questions later on, you can always ask the questions and I will, answer your questions via the Ask Prashanti videos that we do. And just before starting, I wanted to let you know that we do have a YouTube channel. and we post Immigration Fridays videos on our YouTube channel. Every Friday, we pick up a topic and we post a video on it. So please make sure you look at the YouTube channel and like and subscribe. And we also started a new series called Ask Prashanti, which is also on YouTube, Facebook, all our social media, including the Immigration Fighters is, by the way, on all social media. But if you have any questions with reference to Ask Prashanti, what we do is we take questions from the website, from your questions that you ask, from our website, from LinkedIn, from YouTube, and all our social media, and we compile the questions and we answer each question one by one. And this is done again every week, once a week. So put your questions out there, post them on my website or social media, and I'll be sure to answer them. You can also go to our various social media and check out the videos of the answers already given over the last few weeks. So with that, let's go directly jump into today's topic. And today's topic is with reference to family based immigration, RFEs, and how to avoid RFEs, how to avoid denials, how to file a family based petition, basically. So I wanted to start off with the visa bulletin because there was a big jump in the July visa bulletin for family based cases. So for unmarried sons and daughters of US citizens, that's the F1 category, jumped by a month for India. We're only talking about India because India is the most backlogged right now. F2A, spouses, children of green card holders, there was a big jump of 8 months from January 2022 to September 2022. F2B advanced to October 2016, F3 advanced to August 2011, and F4, which is sibling category, advanced to July 2006. Um, and also F2A moved from February to March. That moved by, this is the dates for filing, by the way, sorry. The previous bulletin was the final action dates. That's based on which you can actually get your green card. Dates for filing is basically the table which we use where you can file your green card in advance, but you can file the 485 in advance, but it won't get approved until the final action date becomes current. So F2A moved by a month. F4, which is the sibling category, moved from October to December. That's 2 months. Next slide. So we see some movement on the dates for filing table also. Then employment based categories also, you see there's not much change. Um so why does July movement matter? It's uncommon to see a 8 month forward movement. We saw that for F2A, so we're hoping that this highlights a strong allocation for the family based cases. That means they might have spilled over from other categories, and it's also heading towards the end of the fiscal year, which happens in September. So we still have July and August. September, we expect that there will be a backlog or unavailability since by September all the visa numbers have to be used. So let's see what happens, but it shows that there might be, I'm hoping, some rapid forward movement in family based cases in the coming months. We're hoping to get the visa bulletin for August very soon. If it already hasn't come in, we haven't checked, I haven't checked today, but as of yesterday, August visa bulletin hadn't come as yet, wasn't published as yet. So let's wait and see what's in store for August, but we're hoping that family based cases, there'll be some movement for August as well. Next slide. You can go to the next slide. As I was saying, just this is just a prediction. August should bring for incremental forward movement. Though for employment based, I don't expect much forward movement. EB2 and EB3 might just remain forward, frozen, or there might be a small forward movement. F2A seems to have a good momentum, as I was saying. So watch for your priority dates in the final action date table as well as in the dates for filing table. Next. Now let's talk about a few of the green card categories. Green card options for spouses, children, and parents of US citizens and green card holders. For US citizens, spouses, children, and parents come under the immediate relative category as long as the children are under 21. And the good news is there's no numerical limitation for immediate relatives. Therefore, there is no period for non-availability of green card numbers. So the only wait is the processing time, which is not too bad right now, about 12 to 18 months. You should be able to file and get your green cards. For permanent residents, that's the F2A we talked about. Uh, uh, Forward movement in the visa bulletin, we saw that there was an 8 month tremendous forward movement for F2A. So the F2A is nothing but spouses and unmarried children under 21 of permanent residents. And this is subject to the green card cap. Every year, there's only a certain number of green cards that are released, and it's the same every year. I think it's around 140,000. And then, of course, you might have more green cards approved because there's usually a trickle down from other categories into this category if other categories are not being used, and a trickle down from other countries into oversubscribed countries like India. So we can expect it not as bad as other family based categories. F2A is usually better than F4, for example, but we can expect that. I don't expect it to become current, so there will still be a slow forward movement with reference to um, visa availability, though processing times are, standard for all cases. You can next slide. And green card holders, of course, cannot sponsor their parents. They can only sponsor their or siblings. They can only sponsor their spouse or their children. Now, the next category we want to look at is what happens now if your child turns 21 or they get married, and what is the option for siblings? Of are you able to file for your siblings? So for unmarried sons and daughters 21 years or older, that comes under a different category, F1 category. Uh, for US citizens, for permanent residents, it's F2 category, and there are backlogs for both. And there's a huge backlog for green card holders versus US citizens. So there's a big difference between F1 and F2, F2B. But these are subject to the numerical limitations. Therefore, we often see that there is unavailability, or there is, availability, no availability for maybe several years. So that's something to keep in mind. Married sons and daughters, we were talking about unmarried, 21 years and older, unmarried sons and daughters come under F3. And for green card holders, unfortunately, there is no option to sponsor married children. Brothers and sisters comes under F4, again, severely backlogged. I think they're working on 2006 right now. And green card holders, only US citizens can sponsor their siblings, green card holders cannot. Next slide. So let's look at the key factors for green card approvals this year. With the present administration, things always change, especially when the political climate changes. So let's look into what changes, if any, we can expect under the present administration. Some of the key factors is, of course, number one, you have to look into sponsor requirements to make sure that the sponsor, the US citizen sponsor, has an income above 125% of federal poverty guidelines. This, of course, is based on household size. Just to give you an idea, it's about 25 to 30,000 for a household size of about four. And of course, domicile is important. The sponsor has to be in the US or show a strong intent to reestablish residence in the US if they have been abroad for a few years. Coming back to the financial requirement, if the sponsor is not able to show that kind of income or property or um, other assets, then they can always get a co-sponsor. So they'll fill out an affidavit of support, which is the I-864, and the co-sponsor will always also fill out the affidavit of support, and then the co-sponsor will have to establish that they meet the requirements. Common other issues that we see in 2025 is with reference to finances, the income being low, especially for people who are newly employed or sponsors, citizens who work overseas, or um, sponsors who are self-employed and maybe don't show much profit in the tax returns and don't take a W-2, then it's difficult to show that they pass the income requirement. We also see that there are a lot of errors being made this year when people are filing cases. They're filing outdated versions of the I-864, incorrectly calculating the income. So we've received some RFEs from people who have tried to file themselves and then come to us to work on the RFEs. I've seen this. And since the forms have been updated this year, I've seen that they've been using the old forms as well. So keep that in mind. Also, I've seen issues with lack of tax returns, employment letters, cases being sent without that, and then we get RFEs for the latest tax returns and sometimes for the tax transcripts. And sometimes with reference to tax return, we get RFEs if it's especially a joint tax return and you don't submit a W-2. They want to make sure that the individual person who's sponsoring, they want to get their income separately, which may not be there in the tax return. So they, then ask for W-2s. As I said, there can be a joint sponsor or co-sponsor, and the joint sponsor should meet all the requirements required by the sponsor and submit all the required documents such as tax returns, I-864, W-2s, etc., etc., and make sure that it's well organized so that you can avoid an RFE. Next slide. Um, Another key factor is establishing a bona fide relationship. And this is especially important in marriage based cases. As for marriage based cases, there's already always a presumption of fraud, that it's a fraudulent marriage and the marriage only took place so that the person can get a green card. So it's very important establishing a relationship. In other instances, say, especially in brother sister instances, it could be an issue. If you are applying for your biological brother and sister, may not be an issue because you then just have to submit a birth certificate for both showing that you have the same parents. But sometimes it can be an issue if you're doing it for a half sibling. Then you have to show, birth certificates showing that at least one parent is common. And then if you're doing adoption, like an adopted sibling, then you have to show the adoption documents and you have to show that it's the same parents through the birth certificate. So there are different documents required depending on the type of relationship that you're seeking to prove. For marriage-based cases, as I was saying, going back to marriage-based cases, there's a stricter scrutiny, especially under the present administration. Earlier, the interviews for all marriage-based cases, interviews were discretionary. Although marriage-based cases usually had an interview, but I was seeing cases where they were getting approved even without interview. Unfortunately, now under the present administration, especially for marriage-based cases and more often for other cases, you will see interviews. I think in marriage-based cases, most cases will get interviewed. So you will see additional scrutiny at the interview, and you might find that they ask more questions or that they separate you for the interview and do kind of a Stokes hearing, a Stokes interview, which is where they separate the spouses and they ask them questions individually. So that's definitely something that will happen under this administration. Make sure you submit documentation to show that you have a bona fide marriage, that documentation to overcome this additional scrutiny. That documentation could be joint leases, tax returns, utility bills, photographs, birth certificates if there are any children that you have together, and a document showing that you are leading a shared, ongoing shared life. And try to avoid red flags if you're not living together. It's a long distance relationship. If there are inconsistent answers, large age gap between the spouses, no shared assets, they're not on your, for example, on your 401k plans, or they're not on your health insurance, or you don't speak the same language. So all this, it could lead to document fraud, and that could lead to denial of the green card. Next slide. Um, Now, there could be issues with reference to admissibility also. Now, we've talked about relationship, we talked about finance. Let's talk about admissibility. Uh, un- because of certain reasons, your case might get denied because um you might, uh, they might say that you're inadmissible. So grounds for inadmissibility 221A is any criminal convictions, any immigration fraud, unlawful presence, health issues. All these can lead to inadmissibilities. Let's talk about one at a time. Any criminal convictions, especially if you've had a felony, if you've been convicted of a misdemeanor, it's possible that you might have a petty offense exception, especially if the misdemeanor has a jail sentence of less than 6 months. If it's a felony, then you might be able to file a waiver, and we'll come to that later. Immigration fraud is if you submitted incorrect information at the consulate or with USCIS with your green card petition, then that would be considered to be immigration fraud. Unlawful presence is if you've been out of status for more than 6 months, meaning your I-94 is expired and you continue to remain in the country for more than a 6 month period, that's unlawful presence. So if you leave and come back, you may not be allowed back into the country. Certain health issues, you're supposed to do get a medical report from a certified doctor, and if they find certain health issues, then they can deny it on that basis. COVID vaccine is no longer a requirement under the present administration. So under that, for the when they're filling out the form 693, which is the medical form, they can just strike it out or put it as NA. So that's something new under the present administration. Now, if you are inadmissible, it's possible to file waivers, provided you meet the requirements and grounds for inadmissibility. It depends on what extreme hardship your US citizen relative will face if you are not, if you're not allowed into the country or you're not allowed to remain in the country. This is again difficult. It's a complex requirement. Denial rates are pretty high, and it's document heavy. So, since it's discretionary, they can completely deny a waiver as well. Next. Now, reasons for green card rejection, again the same as what to look into: eligibility failures, inadmissibility issues such as undisclosed criminal records, past frauds or misrepresentation. So it could be something that happened in the past. Um, that could be something that affects your green card. Could be that a visa was revoked in the past. Maybe there was some issue with your F1 when you are on STEM, OPT, or maybe when you are as a student, maybe your CVS was revoked and then you were able to get back into status, but maybe that will count then as an inadmissible issue, especially if there's fraud. Overstays, as I was saying, definitely are an issue, and health-related issues also could lead to inadmissibility, as I discussed earlier. Let's go to the next slide. So then it's the same reasons. Financial deficiency, we talked about that. Procedural errors. If you use outdated USCIS forms, we talked about the I-864, but the 485 could be outdated and they'll just reject it. If you're missing signatures, if you don't submit certain documents, or you submit incorrect documents, you submit the wrong filing fee, or you submit a check which is not signed or incorrectly filled out, if you don't attend biometrics on time, all these will lead to delays. These are all procedural issues, but they will all lead to delays or rejections. Next slide. And we discussed misrepresentation and fraud, submitting false documents, lying during an interview, especially if it's a marriage based interview or maybe it was a visa interview, inconsistencies between what you say and what you put on your form. That could also lead to a fraud finding. So basically, keep everything in mind when you're starting your case. Disclose all the information to your immigration attorney, and so that you can preempt any of these issues and submit waivers if required. Next slide. Now let's talk about a few common RFEs that we receive, and I think I will skim through this. You could receive a request for further evidence, a notice of intent to deny. RFE just means that your documentation is incomplete and they're looking for, more documents. Denial means that they intend to deny it, so it's a stronger case, and they're giving you one last chance to respond. Usually, you only get 30 days for a NOID, but you get for an RFE, you get 87 days to respond. Of course, consequence of not responding is denial for either one of them, that goes without saying, or responding late or responding with incomplete document is all will result in a denial. Next slide. Let's now go through some common RFEs that I've received recently under the present administration. This one, as you can see, is for medicals. We submitted the medicals, but the case took a long time to process, so they've asked for the medicals again. So this is what it looks like. Submit a complete form I693 report of medical examination and vaccination record, complete by US civil surgeon. We will not accept photocopies of medical exam results. They have to be sealed and submitted in original, and the civil surgeon must sign it. So these are all the instructions for a medical form. As of 2024, all applicants aged 2 months or older must have a polio vaccine, and as of 2022, all applicants aged 59 must have hepatitis B vaccine. So these are new requirements, especially the 2024 one. 2 months or older, they're asking for polio vaccine to be done. Though that might be removed by the present administration because they're not in favor of vaccines, but let's wait and see. Next slide. This is another RFE that I wanted to share with you with reference to affidavit of support. I told you if the affidavit of support is not submitted properly, if the tax returns are not submitted properly, or if it's a joint tax return that's submitted and you have not submitted pay stubs or W-2s to show what the individual income is of the sponsor, then they usually send RFEs like this. The joint sponsor in form I-864. This is in case of a joint sponsor. Usually, in cases of joint sponsor, I always see that very often there's an RFE for whatever reason. So in this case, also, this is the joint sponsor. The main sponsor did not have the financial ability, so we used the uncle in this case. So that's a joint sponsor. There, we did submit the tax return, but I guess the W-2 was not submitted, so they're asking here. Of course, this is just standard language. They're asking for W-2. They're asking for basically income tax return. They're asking for documents related to Form I-824. These are all the instructions. They're saying based on documents submitted, we could not determine the petitioning sponsor on Form I-864 affidavit of support is qualified. In order to be qualified, the petitioning sponsor must meet the income requirements of 125%. Next page. And therefore, they're asking for I-864 affidavit of support to be submitted, joint sponsor's social security number has to be put on the I-864, complete a complete copy of the W-2s, 1099s, tax returns, etc., etc. So this is a typical RFE that we receive. And they're saying that if the tax return don't show enough evidence, then submit proof of assets such as bank statements, stock, shares, any other equity that the sponsor has. Next slide. So this is interesting RFE where they're saying basically that the name does not correlate, and they're saying that the reason that the name doesn't correlate is that they're giving two names here. I don't know if you can see it. If it's, can you make this a little bigger?
I don't have a way to make it bigger. No.
Okay, no problem. So they're basically saying that the order of the name is different. Obviously, I had to write out the names, but the order of the name was different. The first name and last name was mentioned in the birth certificate, whereas in the passport, it was the first name and the middle name, or, that was basically the issue in this case. So we had to show that the person is the same, and the way we showed that, they gave some examples of what you can show. Of course, we submitted affidavits from people that know them, that they are known by both names, basically, and we submitted other ID proof to show that they are both the same person, the person in the passport and the person mentioned in the birth certificate. We try to correlate both by showing other ID proof and by showing affidavits. So this is another thing that can come up. So if you see that the names are different, because usually in a birth certificate the name will always be, they'll just write one name because this was done at the time of the birth. So sometimes they'll only put one name. Sometimes they don't bother to put the last name. Sometimes the name changes after marriage, especially in the Indian scenario. So this might be a RFA that you receive. Next slide. I think we're done now, so we can take questions, and if we are done with the questions, then we can take this up.
Yes. So let's do that. For everyone listening in through any of your streaming platforms, whether it is YouTube, LinkedIn, Facebook, or directly through the streaming, you can use the chat window to type in your question, and we'd be happy to answer. Prashanti, we were able to go live midway through on Facebook and LinkedIn.
That's good. So maybe we'll get some questions from there. I'm not sure.
Yeah,
Do we have any questions right now on the live stream?
nothing on the live stream just yet.
Okay. So let's go ahead with the answering the questions that we got earlier, and then if we do get any questions, then we can answer them. And please ask any questions can be asked. It doesn't have to be about family immigration. You can ask your question about your H-1B or your green card, anything that you have.
Great. In the meantime, I can ask this long question. Uh, I'm currently in the US on an H-1B visa, working in a full-time role as a senior principal consultant. My job role is Oracle ERP Financial Functional Consultant. I hold a bachelor's degree and an MBA in financial management from Indian universities. I have over 14 years of experience in Oracle Finance, having worked in multiple countries, including the Philippines and the Netherlands. I am now considering pursuing an MS, Master of Science in IT Management from Colorado State University. global, and online course. My primary reason for pursuing these degrees are to enhance my education for career growth, to meet immigration requirement. Question: can I enroll in an online MS program while on an H-1B visa? Do all Master of Science programs qualify under the STEAM program? If the program falls under the STEM category, would there be any disadvantages in pursuing it online? Will this degree combined with my work experience as an Oracle ERP consultant qualify me for for a specialty role? Is an online MS program recognized by USCIS for H-1B extension petition in the future? If the degree certificate specifies online or global campus, would that impact its recognition as an STME category higher education?
So, from all this, we basically have two questions. Actually, only one question if you can condense it. But the question is, can you do an online program and get the benefit, get an immigration benefit from it? Answer is no. If it is completely online, first of all, I don't think you'll get STEM OPT because you have to be on an F1 to get STEM OPT, and you cannot do a completely online program and maintain F1 status. So that won't be possible. Second, in order to meet the requirement for, say, a green card, because for a H1 you don't need a master's, you only need a bachelor's, but say your bachelor's is not related, and so your question is valid. If you have to look at it for a master's, say, um, again, it has to have classroom instruction. A completely online program is not recognized by USCIS. The last time I checked, so there has to be some amount of uh, program or classroom teaching or in-person classroom teaching. So I would say no, you won't be able to use this online MS program for STEM or for your future H1 or green card.
Okay. We will take the next one from a screen. It is from Madhur Tiwari. Madhur asks if any break in US stay, example H-1B, is not extended, then would this be a problem?
Is this from the chat or?
Yes, from our chat, yeah.
Oh, okay. Can you read it again? Sorry.
Yeah, no problem. It's from Madhur. Madhur asks if any break in US stay, example H-1B, is not extended, then would this be a problem?
Yes, if you have a break, if there is a break in US, I mean, I don't know what you mean by any break in US stay. If you are in the US and you don't extend your H1 and your I-94 expires, then it is a problem. But if you leave the US and you do not extend your H1, if you're outside the country, then US immigration laws don't apply to you. So then it's not a problem. I hope that I answered that. If I didn't, just send another question.
All right, we'll take another one from our website. I got my I-120 approved on EB1C with priority date of November 2023. As the date is not current, would I be able to file for EAD and change my job?
Um, so I think instead of I-120, it should be I-140. I think the person might have mistyped it. So I got my I-140 approved in the EB1C category. There's a priority date. So since the date is not current, you cannot file for a 485. Since you cannot file for a 485, you cannot file for a EAD. And since you cannot file for a 485, you cannot make use of the AC-21 law, which allows you to change your job once the 485 is filed and the I-140 is approved. So both have to take place in order for you to make use of the um, AC-21 requirement. So it's no in both cases.
All right. Um, So we have some explanation from Madhur on chat. Madhur mentions was in US and H1B not extended and came back and in US only.
Left and came back. So when they were in the US and if the H1B was not extended and if they were out of status and the I-94 expired, then you have uh, came back from where? So if if you were in the US and your H1 was not extended and I-94 expired, then you're pretty much out of status. So I'm not sure how you came back and what is your status now.
Madhur, I can also suggest if you want to have a one-on-one session with Prashanti, feel free to reach out. We will be sharing Prashanti's contact details. And I would actually like to take this opportunity to thank everyone for joining today's call. And as a token of appreciation, we are in fact giving away a complimentary consulting session with Prashanti. So if you, Madhur, and or anyone in today's webinar is interested, feel free to drop in your email address either on chat or directly on any of the platforms through direct message or email. And then we would be happy to um, reach out to you. I'm sharing Prashanti's detail right here in the screen as well. Um, and yeah, a reminder, we still have a few more minutes. So if you still have any questions unanswered, you can drop in. We would be happy to take in. Prashanti, in the meantime, I will go back and read out some questions from offline. I'm currently in regular OPT until May 2026. My company is planning to start the process for my green card soon, but our lawyers are telling us that the process takes 2 to 2.5 years, which would be after my OPT expires. The question is, once we submit my application, would it be possible to get a temporary work permit while I wait for my green card slash priority date? I know that in EB2 and IW, that's not an option, but not sure how it works with company sponsorship. Any advice would be helpful.
It's the same thing with company sponsorship as well. In order to get a EAD card, you have to file the perm. I mean, the perm has to be approved. I-140 has to be approved. Your priority date has to be current based on your, the date that you applied, the labor cert, that's your priority date. And then if it's current as per the visa bulletin, then you can file for 485. And then after you file for the 485, you can simultaneously file for adjustment of status as well. So you have a long way off, but if your dates are current, then you could get an EAD. Uh, that is if you don't belong to India, because India no dates are current. But if dates are current, it's possible, or if you're able to transfer your priority date from an older priority date, then you're looking at prevailing wage taking about 6 months, perm, which has to be filed after that, taking about 1.5 years. And then an I-140 could be filed in preview processing, which could take about a month. That, if your date is current, then you could file for adjustment of status and you could file for EAD. Otherwise, you have to wait.
All right. Uh, Prashanti, back to chat. Mathur gives another explanation slash question. After approval, H1B again came to US back, so that gap would be an issue in my previous approved previous approved 140 to get GC question.
Again, it depends on how long you stayed out of status, how long you stayed after your I-94 expired. If you stayed for more than 6 months, then if you left and came back, I think you've incurred unlawful presence. And if that comes to their attention, then for a green card filing, that uh, could lead to a denial. So because you'll be inadmissible and then you have to file a waiver. So I don't know if it's more than 6 months or less. If it's less than 6 months, then that may not be an issue because there is another something called 245K, under which out of status period of 6 months is forgiven under 245K. Also, if you have left and come back, they'll look at for your 485 filing, for green card filing, they'll look at only your status from the date that you last re entered. So, other than unlawful presence, if you are not subject to unlawful presence, then other things may not be an issue for your green card.
All right, we got another one from chat. This is from uh, Gnana Mokan Krishnan Stentu Jyoti. Um, if a EB based GC was approved, can we retain the same priority for a new I-140 petition in the event the previous LPR status was abandoned?
Uh, the green card was approved. Interesting. I presume you can, but I'm thinking that it must be a really, really old I-140 petition. But you can definitely ask for your priority date to be transferred from the old I-140 to the new I-140 that you're filing now. I think it can be done, but I'm presuming that it must be really old. If you already got a green card and then you abandoned it and then you're coming back again to file for a green card, I would certainly try. I think it can be done. I don't see why not.
Sounds good. Uh, we will leave the chat window open for another minute or two for any of you to ask any further questions. Prashanti, on that note, I would like to remind everyone that Prashanti now, other than coming online on once a month weekly sessions, sorry, once a month, yeah, once a month webinar sessions, I apologize. Prashanti is also answering questions on a weekly basis through Ask Prashanti video series. So, throughout the week, if you have any questions, you can reach out to us on any of your social platforms that you are connected on, whether it is Facebook, Instagram, or LinkedIn, or even YouTube. Drop in your question so that Prashanti can pick that up for her Ask Prashanti video series. And then we will be announcing dates for the next webinar very soon. We do apologize for the early inconvenience through our LinkedIn and Facebook streaming that we faced earlier today. We will be reaching out to the streaming platform service provider to find a resolution for future webinars. On that note, Prashanti, thank you so very much for your time today. And yeah, we look forward to the next session soon.
Thank you. Thank you, everyone, for joining, and thank you for your questions.
All right, everyone, we will end today's stream now. Have a good one.